We are not yet complete. Asma Jahangir is still missing, but I guess she will join us in a moment. Welcome back to the afternoon session. We just received also written information about the ratio of women among judges. I'm very grateful to these statistics. Yeah, in the afternoon we start with, and I would say we take the different articles separate one by one. So we start with Article 6, the right to life. Again, many thanks for all the written replies to our list of issues. Would a representative of the government like to say a few words by way of introduction? Or shall we start with the questions?
Yes, please proceed. Please proceed. Please proceed.
Perhaps I should start by explaining our deep concern about some of the developments. As you know, that we were informed in December that the execution of some of the death row inmates could occur, and we have deliberated among not only the 5 members of the CCPR committee, but of around all 10 members, and we all of them authorized the 2 chairs, Eibe Riedel and myself, to send a letter to the Minister of Justice and to the President of Taiwan, expressing our concern and requesting that any executions should be stayed until we would have the possibility of discussing this serious issue with you, because the death penalty is playing a prominent role already in the state report, but also in the shadow reports in relation to the right to life and in relation to the prohibition of all forms of cruel, inhuman and degrading punishments. This was not an open letter. It was a private letter addressed, and that is in accordance with the usual procedures, that whenever, in particular also in individual complaints procedures, whenever there is a complaint regarding to the death penalty or regarding to expulsion, then usually a request for interim measures is submitted to the respective government, not to take any action that would have irreversible effects until the committees would have the opportunity to consider this case. And we were sure that the government of Taiwan, having invited us to review the state reports, would comply with our request. Shortly thereafter, we found media reports, and we were flooded by emails from all kinds of concerned citizens of the country, accusing us, sometimes in very harsh and insulting language, of interfering with the internal affairs of Taiwan, what would come into our mind as foreigners to request the government of Taiwan not to execute persons on death row. So first of all, I said this was a private letter. It was not a public letter, but it obviously has been leaked out to the media and to the public at large, and it created quite a heated discussion in Taiwan, but also abroad. Also international human rights organizations were informed about this letter and debated it. So we were shocked that this has happened, but we were even more shocked that soon thereafter we were informed that 6 persons on death row actually had been executed, notwithstanding the explicit and urgent request of all of us to stay these executions until we would have the discussion on the death penalty today and would be able to formulate our concluding recommendations. It might well be that our deliberations might lead to the conclusion that the one or the other case of executions violated Article 6 and or 7 of the Covenant. But it's now kind of moot if we discuss these cases if the people already have been executed. So I have been authorized, and again I'm speaking on behalf of both committees, to express our most sincere concern about this matter to you. But nevertheless, because there were also certain rumors in the media, but rumors which were based not on any kind of interviews with any of us, because we refused to speak to any journalists. We refused to respond to any inquiries by the media, because we said this is our policy. It was a private letter, and we are not dealing with these serious issues with the government of Taiwan via the media. So we did not respond to any media request. Nevertheless, the media reported that the committee might rethink their entire engagement with the government of Taiwan, which is not what we did. We discussed this issue among ourselves, and we came to the clear conclusion, however serious this incident was in obstructing our good relationship, nevertheless, we felt it our duty, after having been invited by the government of Taiwan, to continue our constructive dialogue with the government of Taiwan on all human rights issues, including, of course, also the issue of the death penalty. But I wanted to bring this to your attention, and of course, this serious incident will also be reflected in our concluding observations as a way of not taking our request in the seriousness it should have been taken by the government of Taiwan. I don't know whether you wish to respond to this statement of mine on behalf of all the committee members, or whether you want me to continue with putting questions to you in relation to the right to life. Please.
Mr. Chairperson, distinguished experts, we know that it is an international trend to abolish death penalty. The Taiwan government is also working toward that direction. What you said is most inspiring. In regard to the effort to abolish death penalty, Taiwan government has started amending laws in this regard, hoping to reduce the incidence of death sentence. We no longer have absolute death crimes. So for those who are under the age of 18 or over the age of 80 shall not be imposed by a death sentence. At the same time, we have been reviewing the death convicts. If the seriousness of the crime is not that bad, we would reconsider, and we would also provide different means of relief for the prisoners. And judges are also encouraged to consider different sentencing mitigation factors. We also pay attention to the execution of death sentence. For example, if a death sentence is decided, it has to be a unanimous decision among the 5 judges of the Supreme Court. And there should also be the full defense for the death sentence verdict. And at the same time, we asked prosecutors to be more cautious about their request to impose death sentence. We also reinforce protection of the victims and promote the restorative justice. At the same time, we want to improve our public order so as to deter would-be criminals. At the same time, human rights education will be promoted among different sectors of society. We are also aware of the incident you mentioned. We know that after the verdict is done, many different aspects have to be taken into account if we want to address the death sentence issue. According to some public opinion polls, 78% of Taiwan's citizens still support the use of death sentence, putting the Taiwan government into a predicament. 78% versus 22%, there's still a big gap. In 1991, 59 executions took place. In 2011, it's dropped to 5. So we hope to take a gradual approach to abolish death penalty. So the ultimate goal is to abolish death penalty, yet this is going to be a long journey. We can also learn from the experiences of other countries that have abolished death sentence. The United Kingdom took 30 years, and France and Germany took almost 100 years to attain that ultimate goal. So we are still on the way towards that destination. We will keep working towards the ultimate goal of abolition of death penalty. Thank you. Mr. Chairperson, you talk about the letters to President Ma and the Minister of Justice, and it was leaked to the media. I am a staff member of the presidential office. I would like to apologize to all the review committee members. We know who leaked that to the press, but I'm not in a position to name the person or persons. We just want to apologize for the inconvenience caused.
I just want to point out that every country that abolished death penalty, there has been always a public opinion against abolition of death penalty. But it has been abolished, just like there is a huge public opinion against incarcerating public figures for corruption, and yet you have to do it. So I think that there is one point of taking public opinion, and the second is to respect international rule of law. And the international rule of law certainly just points towards abolition. And we take your point that it's a gradual approach, but I hope it's not a very, very long journey, because we have to catch up rather than wait for another 30 years. And I do hope that even when public opinion is being made, that more research can be done and people can be, told, because you have now at least a state television and radio, that people can learn more about how death penalty has, in many ways, it's a human rights violation, and in many ways also people have suffered because of misuse of death penalty.
Thank you. I would just add, in many countries, including my own country, when my government abolished the death penalty, certainly the majority of the citizens of Austria were in favor of capital punishment. I think there are certain issues in order to comply with international law that governments have to do, even if it is against the public opinion, which sometimes might be agitated by certain of the media. It's the government who has an educational function, an awareness-raising function, in order to explain why certain actions are needed in order to comply, and that is the deliberate and explicit desire of the government of Taiwan, by having ratified those two international covenants, by having implemented them, in order to bring your domestic legal system in accordance with international human rights standards. And I think not only Article 6 is very clear about the tendency towards abolition. If you look into the most recent General Assembly resolutions on abolition of the capital punishment, requesting all states, at least as a first step, to introduce a moratorium. And if I may refer to the latest reports of the current Special Rapporteur on Torture of the United Nations, Juan Mendes from Argentina, who is clearly establishing there's an evolving rule of customary international law, that the death penalty per se constitutes inhuman or degrading punishment, and therefore there is an evolving customary rule that the death penalty is no longer in accordance with international law. But let's perhaps go to the questions that were raised in the list of issues. And the state report itself seems to acknowledge that the death penalty is an inhuman punishment. If it says the death penalty is brutal from the perspectives of humanity and the covenant. That's paragraph 94 of the state report. And then the report continues, policies on how to abolish the death penalty are yet to take shape. But if we look into the response on the efforts taken, on the one hand, as you have said, there were certain measures introduced to only apply the death penalty to most serious crimes, not for juveniles or for persons over 80 years of age. But the ultimate goal of abolishing the death penalty I had the impression that a body has been established which has not been working in the way as it should be, and if I'm rightly informed by the non-governmental organizations involved, that they actually have left because of lack of progress in relation to the abolition of capital punishment. Now, I also would like to remind you that there were 3 years in which Taiwan has been de facto abolitionist, where nobody has been executed, whereas in the 3 last years, the number of persons executed is actually again on the increase. Last year, 6 persons have been executed as compared to 5 in 2011. So these figures do not indicate a genuine tendency towards abolition. They seem to indicate an opposite trend. How would you respond to this accusation, which is not coming from me, but there were quite a number of non-governmental organizations which addressed us and which in a very, very strong language said that the government seems to have abolished their efforts towards abolition of capital punishment.
Regarding this question, I think I have the following statements. The government indeed has a research and implementation group on gradual abolishment of death penalty under MOJ. And MOJ usually set up the meeting dates 1 year ahead so that the group members know what dates they are supposed to be there at the meetings. We also set up topics that are to be discussed at these meetings and give advance notice of the group members so that the members know what to discuss. However, if the attendees is 50% or less, that's the total number of the group, then this meeting will not be held. So before the meeting takes place, we call each and every of the group members to see if they can attend. And if there are less than 50% of them who can be there, then the meeting will not be held. That's why some meetings were not successful. But indeed, there are many topics that we want to that are to be discussed. For example, we want to decrease the application scope of death penalty, and we need a system to establish a system to protect the victims. MOJ, under the goal of promoting restorative justice, we need to come up with a comprehensive system. And the consensus or the polls or the surveys, the way we do it is very important. Of course, as you said, public opinion is not the only indicator of whether we should abolish death penalty or not. Last September, before we went to Germany to pay an official visit, and the German's office in Taipei told us that if we went to Germany, then death penalty will be high on the agenda on the topics that we're going to discuss. And we asked the German officials why Germany was successful in abolishing death penalty. He told us that the public opinion is support is supporting the death penalty, but the government is determined to abolish it, and that's why they went ahead to do it. So we understand that public opinions is not the only factor to determine whether the death penalty should be abolished or not. I think what we need to do is to use the power of education to educate people, making them understand that death penalty is a form of torture, and the abolishing of death penalty is an international trend. So we hope that it won't take 30 years before we can abolish death penalty. We have 27 members in the research group, and 9 of them quit the group after the 6 executions were made. They quit to protest the fact that the government was not doing hard enough to promote that the goal of the ROC government is to abolish death penalty. But we told these group members the true intention of the government and our ultimate objective, and we want these group members to come back to the panel. So a group member, Mr. Yang, said that there could be some alternatives to death penalty, and he's willing to come back to the group for further discussions. And now we're working hard on inviting the other 8 members to come back to the panel to continue to have the discussions and the debates, so that we can finally realize our goal to abolish death punishment. As to what efforts the Taiwanese government has made to decrease the cases of death penalty, on behalf of the Judicial Yuan, I would like to make the following explanation. The recent cases made by the Supreme Court have taken into consideration of Article 6 of ICCPR. They carefully determine whether the crime is the most serious and the most heinous crime, and that before the sentence is given, there has to be an oral argument on sentencing. And since December 2012, there have been 3 cases that had oral arguments. And the first case was sent back to the second instance, and the second case was the sentencing of that is changed to lifelong imprisonment, and the third case has not been decided yet. And in the current criminal procedural law, in the third instance, there is a mandatory defense, but the draft or the revision draft of the criminal procedural law stipulates that mandatory defense has to be provided at the third instance. And Article 289 is being revised at the Legislative Yuan right now. It stipulates that the scope of the sentencing, an oral argument should be organized for the scope of sentencing after the oral argument is made on the application of law and on fact-finding. And the Judicial Yuan is considering the possibility of using the principle of unanimous agreement on fact-finding for this kind of cases. Thank you.
cite from the parallel report of NGOs just 3 of the headlines, saying the commitment to reduce use of capital punishment has turned into empty rhetoric. The disappearing policy of abolition of the death penalty. And the third one, only a moratorium can realize reduction of the use of capital punishment. You have indicated that 9 of the 27 members in the group that was deliberating on ways and means of how to abolish the death penalty have left after the 6 executions, and you would like to try to get them back on board. So one way, I would think, of regaining their trust that this is a serious endeavor would be to issue a moratorium. That is what many states have done. That is what the General Assembly is explicitly requesting all states to do, to issue a moratorium for a certain period of time in order to also test whether or not this has a negative effect on the crime rate. Because one of the standard arguments of those who are in favor of the death penalty, including, I guess, members of or citizens of Taiwan who are in favor of the death penalty, is the alleged deterrent effect of the death penalty, which in many scientific studies has proven to be wrong. But by introducing a moratorium, one can see whether or not the crime rate, heavy crime rate for which the death penalty could be imposed, is actually on the rise or not. And that would be a measure, as I said, of trying to get trust again, also of the NGO community, to work together with the government towards abolition. Has the government so far considered introducing a moratorium in accordance with the call of the United Nations General Assembly?
As you mentioned, moratorium. In fact, as we responded, the group that I just mentioned, one of the group member mentioned maybe we should use life imprisonment to replace death penalty. And the group members have to come up with a resolution reflecting their idea of using life imprisonment before they can send advice to the other branches of the government. So the fact that I mentioned that we want to invite them back to the panel is not a hollow promise. We want to sincerely invite them back to together with us discuss how we can abolish death penalty in the end.
Does it mean, I'm coming back to my question, that a moratorium has not been contemplated so far? Has it been discussed? Has it been disapproved of, or is it still somewhere on the agenda? I'm asking this question also because I do hope that our constructive dialogue during these days might assist you also in this highly sensitive issue, and I fully recognize that in a country where you have more than or almost 80% of the population being in favor of capital punishment, that it's not such an easy task for the government to immediately abolish capital punishment. But since it is an explicit policy of the government to work towards abolition, one of the most successful ways how other governments have introduced such a process was by declaring a moratorium for a certain period of years. So that's, if this would come out also of our deliberations, of course it would have an impact on our concluding observations and recommendations. So that's why I'm sorry that I have to repeat this question. Perhaps you would also like to deliberate about it and come back to us tomorrow with an answer. But so far I'm a bit unclear whether this issue has been on the agenda and whether there might be possibly a commitment towards a moratorium.
On the issue of our policy toward abolition of death penalty and whether we continue to perform executions, I think these are two separate issues. Whether we want to abolish capital punishment can be discussed, debated in different settings so that people from different quarters of society can continue to communicate with each other before a consensus can be reached. Are we going to announce a moratorium immediately? This is going to be a policy decision. As I said, in 1991, 59 death row inmates were executed, and in 2011 it was 5. Last year, 6 prisoners were executed. But going forward, I'm sure after you review our human rights record, our government will make the final decision. However, I'm in no position to speak on behalf of the ROC government.
I think what Professor Nowak is trying to impress is that while we sit here and have this dialogue, we're obviously also thinking of various ways and various messaging. And these messages we take back and you take back. But it could be very fruitful for, I think, mutually and for the benefit of your government and for promoting this initiative further, if as a result of this dialogue a moratorium was at least considered very seriously.
In terms of moratorium, as you heard, capital punishment is a very controversial issue. 2 weeks ago, 3 prisoners in Japan were executed. This may be an indicator of the cultural differences between Western and Oriental societies. That's why we now begin with the procedure of law and the substantive law to reduce the incidence of death penalty. And we will definitely reflect upon what you just said and take into consideration as we move toward the goal of abolishing death penalty.
I would only like to to be very clear that we are not sitting here as Westerners or not. We are here international experts who were selected because of our experience in United Nations, human rights law and practice. And it is the United Nations General Assembly, not Western governments. It's the General Assembly by a very broad two-thirds, more than two-thirds majority that has been calling on all countries in the world to establish a moratorium. So that means far beyond Western countries, including many Latin American, African and Asian countries that have taken up this issue, abolished the death penalty, and also calling upon other states to do the same. But I leave the general issue at here. I think still we would be very grateful if the government could still contemplate about this issue before we are starting on Thursday to draft our concluding observations, because as you can imagine, because of this very serious incident that I described before you came, but that while we already have been appointed and notwithstanding our explicit request to stay the execution, that persons have been executed in fact. So that's why I anticipated that the government of Taiwan, in preparation of our meeting today, would have considered the possibility of a moratorium, because it is something, it's a typical practice in the state reporting procedure that governments are coming to Geneva, in this case we are coming to Taipei, with very specific proposals and commitments they make to the treaty monitoring bodies, or in the Universal Periodic Review, they are making them to the Human Rights Council of the United Nations. So I was kind of under the impression that today we would get somewhat further commitments by the government of Taiwan in this relation.
Could I say something before we leave the subject, whenever it's appropriate?
We are not leaving the subject of the death penalty, but a moratorium. Please, please.
I appreciate the progress that has been made with respect to improving the procedures and other aspects relating to the death penalty. I especially appreciate the fact that people over 80 are no longer eligible for the death penalty. So I come here with a certain sense of relief. I feel more personally secure. I hadn't realized until a moment ago that there was a cultural kinship between the people of Northeast Asia and their Confucian Buddhist traditions and the people of American states such as Texas and the other southern states that seem to delight in the continuing imposition of the death penalty. This is an interesting thesis to explain why we see the same phenomena here in Taiwan and in mainland China as in some of the American states. So I'll have to go back to my academic work and see if I can see a connection. Now, what we're talking about here is the responsibility of leadership. Is a leader of a country someone who says, I'll put my finger in the air and see which way the wind is blowing, so I follow public opinion? Or is the leader of a country someone who takes the responsibility for leading, educating public opinion? And as I understand the international obligations under this ICCPR, governments are expected to lead on this question. Moratorium is the most immediate, concrete way, and there are obviously other ways to do it. Our own New York University U.S. Asia Law Institute has been working with China mainland to try to moderate the excesses of the death penalty, while we hope the mainland will be moving toward its elimination. Unfortunately, the situation there seems quite similar to here. People give lip service to the eventual abolition of the death penalty, while nevertheless carrying it out with considerable gusto. We have a website some of you might be interested in consulting that tries to draw upon the American legal experiences in applying the death penalty. And I suppose in the absence of a moratorium, we should move on to some of the concrete questions that you have to deal with immediately. I have several relating, for example, to pardon, amnesty, commutation, but I think we should take those as the chairman sees fit a little later on. But I thought I should make some general remarks apropos of the introduction of the subject via the topic of moratorium.
Thank you very much. And I would suggest also that the amnesty question is coming up. Yeah. Perhaps we would then go question by question as they were raised by the list of issues, but Asma Jahangir has the floor.
I just wanted to say very briefly, I come from a country where there are 7,500 prisoners in death row. I think one of the largest in the world. But we did get de facto moratorium. And the party that is ruling Pakistan, their own leader, was given death penalty and was executed as a political punishment. Even they found it very difficult, so we understand. I mean, I understand what you're saying. Nevertheless, there was a de facto moratorium for a long time, till there was another person on the death row whose time had come, and he was considered to be a spy. And then there was a huge fight between the military and the political side, civilian side, and the moratorium was broken. But at least it is taking us closer to it. It's taking us closer. And the second thing we found in how this moratorium was put in place was because the Human Rights Commission did a huge research. If you look at the Human Rights Commission of Pakistan's research, it was a very convincing research. And we found from that research and survey was that people think that if you're saying abolish death penalty, you mean forgive them completely. So they have to be told time and again, what we are saying is not forgive them completely, they will still be punished.
Thank you. Would you like to, please?
Maybe I did not make myself clear enough. In this stage, the ROC government has abolished absolute death penalty. Secondly, we are trying to reduce the incidence of death penalty. Many crimes are now punishable by life imprisonment rather than by death penalty. Thirdly, we also want to reduce the chances of applying death sentence. For example, there should be full defense, oral argument before the sentencing decision is made. And when it comes to moratorium, of course, we are open to all suggestions. All I'm saying is we're not going to announce a moratorium right away. But we do have a task force, a research and implementation group on gradual abolition of death penalty. And you talk about the different practices in countries and mentioned in the UNGA. We will definitely take them into consideration. And we also looked into the death penalty situation in mainland China. So all I'm saying is, please give us a little time to work on this.
Now I'm coming to questions that take up some of the more very specific issues related to the practice of the death penalty. The government has a policy of not informing the family before the convict on death row is executed. And we asked what the reasons for this practice are, and I must say the answer that we received from the government is not very clear or convincing. It says when the decision of execution is approved, it must be carried out immediately. As the time between approval and execution is very short, we can only inform the inmate about the decision. Now, according to our information, it's 3 days in between, and we were also told in relation to the 6 persons who have been executed last December that journalists knew the names before they were executed. So perhaps it's the same leakage that also leaked our letter out, I don't know. But in my opinion, 3 days should not be too long to also inform the family. So, and then there's a last sentence saying we should not inform the family either because of the disruption of contact for a long time or because of the need to avoid controversies a leak of information may cause. Could you be somewhat more explicit? I take it if you say it is the governmental policy, we just do not want the family to know, but we would just like to know somewhat better what the real reasons are for this policy.
It was mentioned that Article 6 under ICCPR, well, the question regarding Article 6 ICCPR, as for the reason why the government did not notify the family members before the execution, are the following. Our main consideration is on the death row prisoner himself or herself, because in that situation, the prisoner may be extremely emotional, and based on Article 7 of the regulation on the execution of death penalty, it stipulates that information should not be disclosed. And our current practice is to notify the family members after the execution. We are following the regulation not to disclose information prior to the execution. That is my response. And I also want to respond. The list of the death row prisoners who are going to be executed are extremely confidential. So some journalists make guess. They have their own guesstimates. Sometimes they guess there are going to be 6 or 8, but it's their own guessing. And the 3-day duration is the order of the execution. Sometimes it is as long as 3 days. Sometimes it is as short as 1 day. The longest is 3 days, but the actual number of days is usually 1 day. So sometimes the execution agency may receive the order on the very date of the time they receive the order. And there was a case when the order of execution was intercepted by a journalist. So this prisoner filed for the review of the execution, and then the execution was suspended. Then his case was executed several years after, which was in 2009. So there were sometimes since as I mentioned, there's only 3 days. As long as well, the longest date is 3 days and the shortest date is 1 day. But sometimes the family members are not near, and we do not have enough time or efficient measures to find these family members. And also, as the previous delegates mentioned, it is in the regulation of the execution of the death penalty that this information is disclosed and should not be disclosed. And that concludes my response.
How long in advance must the person to be executed be informed about the fact that he's going to be executed? Is there a clear rule?
After receiving the order of execution, the prison officer will notify the prisoner immediately. Upon when the prison receives that order, the prison officer will notify the prisoner immediately. So it's about 3 or 4 hours.
Between 3 and 4 hours before execution, or? Because I thought it could be up to 3 days.
The time between execution and
3 to 6.
Within 3 to 6 hours, averagely within 3 to 6 hours.
And it also means that a person to be executed has never a chance to say goodbye to his loved ones, to his relatives. It's never foreseen.
that's true. The person who is going to be executed does not have the opportunity to have such communication with family or friends.
You know, one can debate the pros and cons of not notifying the family or only giving the defendant 3 to 6 hours notice in terms of emotion, in terms of public commotion. It's possible to discuss these things. I worry about the legal problems. If you don't notify the lawyer and you don't notify his client, the defendant, it's possible that you won't have the most satisfactory evidence that the legal process has been completed. Has the application for commutation or pardon been completed? I remember a few years ago there was uncertainty whether the person who was executed had actually completed the process for consideration of whether he was eligible for suspension of the punishment. So I'm looking at the practical legal effects, not the emotional, family sentiment, public opinion. I think you want to be absolutely certain that all legal process has been concluded from the point of view of the defendant as well as the Ministry of Justice. I don't know if you have a comment on that.
In terms of remedies in the legal process, well, it doesn't really affect the death row prisoner because in the past 10 years, now the situation in Taiwan is that the time between verdict and execution is not a short time, it is quite a long time. And based on our regulation of the execution of death penalty, it stipulates that there are remedies such as extraordinary appeal, and we need to make sure that if it is a women prisoner, she is not pregnant, and so on. There are some requirements that need to be fulfilled. And there was a case for there was a prisoner who was on the death row for 8 to 9 years. That was a very long time. And during that time, this prisoner had opportunities to talk to the family members or discuss the matter with his or her lawyers. So most of the death row prisoners now are on the death row for more than 1 year, so they still have time. This is one of our remedy.
Question 20. Article 6, paragraph 4 of the Covenant reads as follows. Anyone sentenced to death shall have the right to seek pardon or commutation of the sentence. Amnesty, pardon, or commutation of the sentence of death may be granted in all cases. According to the practice of the Human Rights Committee, the right is not only to seek pardon or commutation or amnesty, it also means that while these proceedings are ongoing, nobody should be executed. That is the point Professor Cohen has made. Now, according to information from non-governmental organizations, in all 15 cases of executions in 2011, 2010, 2011, and 2012, the persons have started such a procedure but the procedure has not been completed in the sense that they would have received a negative reply, a negative decision. So the proceedings were pending while they have been executed. So in other words, according to the information provided by to us by NGOs, all those 15 cases, Taiwan violated Article 6, Paragraph 4 of the Covenant on Civil and Political Rights. How is your response?
I would like to respond. The ICCPR says that the state party shall not have regulations from preventing the death row prisoners from petition for pardon, amnesty, or commutation. So anyone or the prisoner himself can petition for pardon or amnesty. But the Amnesty Act does not have a very clear procedure of the petition of amnesty or pardon. And if the president agrees to grant the amnesty or pardon, then he will tell the MOJ to suspend the execution. If the MOJ does not receive such an order from the president, it means that the president does not agree with the pardon or the amnesty, and the MOJ will continue on with the execution. But currently, the Legislative Yuan has already asked MOJ to review whether it is necessary for the MOJ to revise the Amnesty Act in Taiwan. So in the very near future, we will decide whether we need to revise these acts or whether the procedure should be more comprehensive. Thank you.
I'd like to have some clarification of the language. The previous speaker has several times talked about application for amnesty or pardon. But I think what we're talking about here almost entirely is neither amnesty nor pardon in the way those terms are used in English. We're talking about commutation. In other words, the Chinese says, da she, ta she, jian xing. We're really talking about jian xing. We're not talking about pardoning the person. President Nixon was pardoned by President Ford. But his sentence wasn't commuted. He never was punished. We're talking here about changing the punishment from execution to life imprisonment normally. We're not talking about a general amnesty, and we're not talking about a pardon. So if we're going to use words to avoid miscommunication, I think the focus has to be jianxing, commutation of punishment. Am I misunderstanding your law?
Well, the regulations governing commutation is included in the amnesty law. So basically, we would require that we have to verify whether there are conditions that would allow the inmate to petition for commutation. In the Amnesty Act, amnesty, pardon, commutation, and reinstatement are the 4 parts included in the Amnesty Act. So commutation, according to our law, is part of the Amnesty Act. Therefore, it all falls into the purview of the president. If the president thinks there's a possibility for amnesty or pardon or commutation, the president can ask the MOJ to look into it. So we did not receive any orders or comments from the president. That's why the MOJ would consider that there are no such possibilities or considerations. As for another issue regarding whether the new legislative proposal will make any difference, well, indeed, discussion is ongoing.
Does the amnesty law put a time limit on when the president must respond? I mean, does it say if you don't hear within 10 days, that means he's not going to agree to any change? How do you know if there's no time limit? Isn't it dangerous? Should there be a time limit? What should that time limit be? There may be already one. I know the NGOs have said that there are obstacles to people filing this request for consideration. Is that true? Are there obstacles? What are those obstacles? Should they be cured? Those are practical questions.
According to the ROC Amnesty Act, there are no such provisions as to the time limit within which the president has to reply. There are no provisions concerning the specific procedures either. That's why the Legislative Yuan made a proposal asking the MOJ to look into the need to amend the Amnesty Act. The Amnesty Act was enacted dozens of years ago. It's pretty old. That's why it's not comprehensive enough. You asked about whether there should be a rule about the specific time limit within which the president has to reply. I think when it comes to amending the act, we can definitely discuss this. And should we also allow the prisoners to repeatedly petition for these either amnesty, commutation, or pardon? Basically, we don't have any restrictions on that. No strings are attached to such petitions. But there are no strings or prerequisites for the inmates.
Is the Ministry of Justice actively preparing legislation to resolve these problems? I know you say they've been referred to your ministry, but what is your ministry doing? Do you have a position? Have you drafted legislation? Will you respond in 10 years? This year? What can you tell us?
We will complete it as soon as possible. This is an issue raised within the last 12 months, so we will be working closely with the Legislative Yuan. I believe that within the next 12 months, we will have some result.
In the 15 recent cases, did the Ministry of Justice inquire with the Office of the President whether or not the death row prisoners who were going to be executed had in fact applied for commutation of the sentence? And if so, can you confirm what NGOs are telling us, that all 15 actually have applied for commutation of their sentence?
Indeed, we verified this according to the regulations governing the execution of death penalty. However, we did not receive any reply or words from the president. We were not notified, informed.
Knew that there was a procedure for commutation pending and nevertheless proceeded to execute. Would you agree that you violated Article 6, Paragraph 4 of the Covenant?
I'm not sure we can interpret it that way, because according to the ROC Amnesty Act, there are no provisions concerning the specific procedure one has to follow in handling these petitions. So if we do not hear from the president, we would consider that means there's no pardon. Right now, we basically wait for the presidential office to inform us. But in the future, I think we have to reflect on the way of verifying this information. If we know for sure that this inmate has filed petition, then maybe we should take extra step to verify the result of the petition. In fact, some of these inmates have filed petition repeatedly because these people have been on death row for quite a few years. Since we do not hear from the president, so we basically would consider that it's not pardoned. We can definitely review the procedures further.
Thank you very much also for the commitment to review these procedures and to amend the Amnesty Act. In response to the first answer, we have learned that via the Implementation Act, the covenants are in the legal system of Taiwan between the Constitution and ordinary laws. So the fact that the amnesty law would be in contradiction with a specific provision of the covenant would mean that the covenant has precedence and the covenant should be applied, and the amnesty law should not stand in the way of applying the covenant. But as I said, I take it that this is a problem that is recognized by the government of Taiwan and will be remedied as soon as possible. If there's nothing anymore on amnesty and commutation, then I would go back again to another issue which is also fairly sensitive, and that is organ donation by death row prisoners. It is sensitive, I guess you are aware of this, because there are major allegations against the People's Republic of China for misusing death row prisoners for organ donation. And according to information we received from non-governmental organizations and also to my own knowledge, the People's Republic of China and Taiwan are the only two countries in the world where death row prisoners are allowed actually to, and where the practice is established, that death row prisoners might donate organs before execution. Now, the NGOs also informed us that the International Transplantation Society, for ethical reasons, is strictly against this practice, and in one of the most recent cases have denied also in this hospital to perform an organ transplantation. The government, in its replies to our list of issues, in my opinion, is not very clear. Paragraph 42 states to date, there was only one case of organ donation from a death row inmate before execution of the death sentence in Taiwan. But then it says in paragraph 43, because we do not distinguish the identity of the donors, we have no statistics about the number of the death row prisoners who have donated organs. And also saying the majority of death row inmates applying for organ donation make them to achieve some peace of mind and to satisfy a desire for atonement. Now, when we discussed this in the morning with non-governmental organizations, their explanation for this apparent contradiction was that there is a distinction between organ donation done before execution and after. But I would be happy if you could explain what you mean and what is the actual practice. So how many, let's say, of the 15 persons who have been executed during the last 3 years, in how many cases did death row prisoners donate one or more organs, and whether this was done for the benefit of family members, as in this one case, or in general?
Now, on organ transplant, I have some statistics. Now, among the 56 who are executed, 10 of them have done the donation, and 6 of them have actually finished the donation procedure. As for the number for the past 3 years, I think we need to collect or recalculate the numbers later. Now, in December last year, 6 prisoners were executed. There were 4 death row prisoners. Well, one of them had hepatitis B, and the other prisoner was willing to donate, but his family member was against that. So in the end, there was only one death row prisoner who donated organ. And we think it is the donor's will and the intention to voluntarily to donate organs. And we do not encourage prisoners to donate organs. In all cases, prisoners took the initiative to apply for organ donations. They themselves were willing to do that. And as long as the family members of the prisoner was against that decision, then we would not accept the application to donate organs from the death row prisoners. This is our current practice in Taiwan. But among the 6 who are executed in 2012, only one of them finished the organ donation procedure, and there were 3 prisoners who also signed the consent to donate organs, but due to various reasons, these other 3 did not finish the donation procedure. Now, we don't encourage death row prisoners to donate their organs, yet some death row prisoners want to do this to achieve peace of mind, to donate organs so that he can help some people who are still alive. This is an idea which is rooted in Buddhism. And I can promise you that we do not encourage death row prisoners to do that. And we're not like what the rumors said about mainland China, in which they sell the organs of the death row prisoners. We absolutely do not do that. In the past several years, I think the medical sector had some different opinions. So if organ donation is prohibited under international covenants, then we will not continue to do that. So thank you very much for your concerns and suggestions.
Just one last question from me on this issue. What is the method of execution if the person has expressed that he or she wishes to donate the organ? Is there a different method of execution or place of execution?
If this prisoner expresses the intention to donate organs, we won't reject this prisoner. And currently, but the execution approach will remain the same. Well, in fact, the way of execution changes. We have shooting and injection. There are two ways of execution. And if it is in a shooting case, then we put amnesia on this prisoner, and then we shoot for the heart of the prisoner. And if this prisoner is going to donate his or her organs, then we shoot for the head, the brain. And before the execution, we will ask the doctors to come to the spot of the execution. Then we shoot for the head, and after the doctor determines the prisoner has died, then we will continue with the donation process. So yes, the way of execution changes if the prisoner is willing to donate his or her organs.
Any other questions on the organ donation? If not, the next question is, what are the detention conditions of death row prisoners? Are they kept under stricter conditions than other prisoners regarding constraints, shackles, etc., solitary confinement, rights of correspondence? And the answer of the government is generally no stricter rules or limitations are imposed on inmates on death row. However, again, non-governmental organizations disagree with this, and they say, in fact, the person can only leave his cell for half an hour a day. There are very, very restricted family visits. So could you please explain also? And there were cases also we heard where a person was for quite a long period of time shackled. Are persons on death row kept in solitary confinement, or are they kept together with other prisoners? Are these other prisoners also on death row or not? Please.
Custody environment for death row prisoner is the same with other inmates. their rooms are equipped with fans and the same facilities with other inmates. And starting from 2006, we have not used shackles or other instrument of restraints on death row prisoners unless there are risks for this prisoner to commit suicide or to escape. And then that's when we will put restraints on these prisoners, but usually not. As for visitation rights and communication with people outside the prisons, the current regulations stipulates that family members can come every week, and if there are special situations, we can allow these prisoners to have correspondence with other people who are people other than their family members. And the visitation time is usually 30 minutes. If there's special situation, then we can extend the visitation and increase the frequency of the visitation. Generally speaking, the death row prisoners are treated the same way as other prisoners. That's my response. Thank you very much. Please use the microphone when you talk. And death row prisoners are basically treated the same way as other prisoners. Now, I would like to add something. Before 2006, if a prisoner was sentenced to death, then shackles would be imposed. So maybe some NGOs are still remembering the old times. But we follow some international standards. So after 2006, we follow the covenant. We treat death row prisoner. We do not impose restraints on death row prisoners, and they are contained with other non-death row prisoners. And the death row prisoners and other inmates who live in the same room can encourage each other, and there were cases when some death row prisoners wanted to learn something new. They wanted to learn how to write calligraphy or other new techniques. And on festivals or holidays, we encourage these death row prisoners to invite family members to come to prison and to celebrate the national holidays or festivals with them.
Any other questions on this? Can persons with mental or intellectual disabilities be sentenced to death? And have there been such cases? Again, I should say that the responses we received from the government and from the NGO community differ. We have received a number of cases where persons who have been diagnosed before as being mentally ill were executed, or persons with mental disorders or with a very low IQ, and so there might be some kind of different standards applied, what type of mental disorder a person must have so that he would not anymore be eligible at all for a criminal procedure. But I think the standards in relation to the death penalty, I think under international law are not the same than the standards for being able to be held accountable under criminal law. So could you please explain also these differences?
As for whether mental or intellectual disabled people were sentenced to death, were there any cases like this? I think we can review ROC's laws and regulations. Now, in Article 63 in our criminal code only stipulates that people who are too young or too old will not be sentenced to death or lifelong prisoners. And based on Article 19, it stipulates that an offense is not punishable if it is committed by a person who is mentally disordered or defect and is unable or less able to judge his or her act or lack the ability to act according to his or her judgment. So, based on Article 19 of our criminal code, we can see that if it is determined that this person has mental or intellectual disabilities, then the sentence can be reduced, but it doesn't mean that the death sentence will not be imposed upon. And if the courts have determined this person is mentally or intellectually disabled, I think the only dispute was how the prosecutor determined whether this person is mentally or intellectual disability. And the regulation right now is that it requires an expert witness to make that determination. The courts make the decision on what sentence is going to be given. For example, whether death penalty is going to be given. And in our procedure of criminal law, it stipulates that if the person who is sentenced to death penalty, and if this person is insane, then he or she shall not be executed. Or if it is a pregnant woman, before this woman gives birth, the execution needs to be suspended.
But have you studied the replies of non-governmental organizations? They have referred to very specific cases of persons who, in their opinion, according to psychiatric assessments, were mentally impaired, mentally retarded, to an extent that according to United Nations standards should not have been executed. And if so, would you agree or would you disagree with these allegations?
Well, if there are concrete cases, we will respond accordingly. If this defendant has been diagnosed to be mentally disabled, we will not execute the penalty. This is something stipulated by the law. We will go back and review the cases referred to by the NGO, and maybe there's some miscommunication. We will go back and look into that.
So the Taiwan Alliance to End the Death Penalty says, for instance, of the people currently on death row in Taiwan, at least 2 people, Lin Wang-jen and Chen Yuan, were evaluated by psychiatrists during their trials and found to be mentally ill. Additionally, Wang Chunjin is mildly retarded and Wang Kongwei has a low IQ, etc. Yet they were still sentenced to death. So therefore, the government's claim that there are no cases of mentally ill people or people with other mental disabilities on death row is simply not true. And then they go on. So I hoped that we would get some clarification on those cases from your side, whether you agree with the Taiwan Alliance to End the Death Penalties assessment or whether you disagree.
Thank you for providing us with this information. Tomorrow we will get back to you on this matter.
Generally, there are three issues when you come to mental illness and criminal justice, as you know. One is, at the time of trial, is the person mentally competent to take part in the proceedings and defend himself? The second is, when the case is being tried, what assessment is made of the mental state of the defendant at the time of the alleged offense? So the first question is, can he be put on trial? The second is, when you try him, what evaluation is made of the person's mental capacity at the time of the offense? Now, we're really talking here about the third question. At the time of execution, what is the person's mental state? And should it disqualify him or her from being executed? Now, the time after conviction, final conviction, and before execution can be many years. And people's mental state, especially on death row, can deteriorate. So my question really is, are there procedures in place and being followed to assess the mental situation of a person prior to execution? Not at the time of the offense, not at the time of trial, but maybe long after at the time of execution. That's the relevant question here. And I don't know what procedures you have for addressing precisely that question.
In response to the three issues you raised, the first one is if the defendant is mentally retarded or incompetent, according to the Article 294 of the Criminal Procedure Law, the trial must be suspended before the defendant is considered competent to go through the trial. As for the second issue, if at the time of the commission of the crime, the defendant was mentally ill, then according to Article 19 of the Criminal Code, no, it's not punishable. However, again, this is a diagnosis that has to be made by an expert. If, according to the expert, at the time of the commission of the offense, the defendant was indeed mentally incompetent or ill, then of course the defendant would not be punishable. As for the at the time of the execution, the MOJ can respond. When it comes to execution, between the verdict is done and the execution, yes, there may be a long period of time. At the prison facilities, we do have physicians, psychiatrists, either stationed at the prison or recruited from external hospitals, can be asked to help make such diagnosis. And before the execution, yes, we do have this procedure to check out the mental status of this inmate, even though it's not stipulated in the law. I don't think we have any cases in which the mentally ill people are executed anyway.
The question then is, what kind of procedure do you have? Is it merely a procedure whereby somebody, a doctor, a psychiatrist who works for the hospital, makes that unilateral independent determination? Or is it a procedure where the defendant or family can bring in their own expert? And if there is a conflict, as there often is, how is that determined? Or is it merely a unilateral procedure where the Ministry of Justice has its own expert and there's no opportunity for the defense to have their independent examination?
In this regard, in practice, we would ask experts from hospitals such as the National Taiwan University Hospital to come over, and the psychiatrist may go through all the documents related to this case. And it's not just one psychiatrist that will be involved. Usually there will be a team that is involved in the diagnosis. First of all, we would ask the hospital whether they have the manpower to perform such diagnosis before we send the case to them. During the wait period, the death row inmates, just like other inmates, can file applications to go through such an assessment. There are some cases where the inmate was sent to the external hospitals for examination, or the doctor can come to the prison. And whether the family members should be involved, we would respect the professional judgment of the doctor. In fact, there are some inmates who have been found to be mentally ill. Then usually we would send them to mental institutions for treatment. In other words, the treatment in this regard of the death row inmates is the same as other ordinary inmates.
Thank you very much. From my side, we could conclude the question of the death penalty, unless there are other questions, comments, or also questions from your side. Then on the list of issues, I have only one further question in relation to the right to life, which could also be asked in relation to the right to privacy, actually, but since it was in the state report in paragraph 95 regarding abortion, that the state report states that the actual conditions on abortion and the number of abortions may require precise investigations and more proactive solutions. And our question was what those proactive solutions are and what is the policy of the present government. If I understand correctly, the answer provided by the government, then it was estimated that about 70,000 abortions take place in Taiwan every year, although it seems that women do not have a right to perform an abortion, for instance, during the first 3 months of their pregnancy, but abortions can only be legally performed under very specific medical and social reasons, such as being raped or life-threatening risk or other risks to the physical and mental health. Is that correct? And if so, is the government considering a different policy towards abortion, in other words, towards legalizing abortion further? According to those 70,000 abortions, does the government have any kind of indications how many of them were legal and how many were illegal? Because I almost cannot imagine that under these restrictive laws that 70,000 women carried out legal abortions because it was a life-threatening situation or they have been raped. So whatever further information you could provide on this, we would be very grateful.
Thank you very much for your question. In Taiwan, the number of induced abortion and the way we calculate the number, we separate it into several different categories. For example, sometimes the women take the initiative to report, and the second category is research conducted on the service providers or women, and the third is through insurance or hospital statistic reporting. So these are the three ways of collecting information regarding abortion in other countries. But we don't have the first one. We don't have the initiative reporting system right now. So we use some survey statistics, and secondly, we look into the insurance cases, and thirdly, because RU486 is controlled substance, so we calculate. So we also use the number of RU486, which is used in Taiwan, to calculate the total number of women who had abortions. That's how we came up with the 70,000 number. And when it comes to induced abortion, and women need to follow the law in Taiwan before they can legally conduct induced abortion. And you ask about among the 70,000 cases, how many are illegal, how many are legal. Since we don't have the reporting system, so right now I can only say that we base the use of RU486 and some medical information that we receive.